The court is recording.
All right, thank you very much. Good afternoon. The Appellate Court for the State of Connecticut is back in session. For the record, we are conducting this hearing virtually via Teams and are live streaming this hearing on YouTube. Counsel advised that to the extent that there is statutorily protected parties and or information here, that you take care not to reveal any protected information. I would ask that everyone participating in the hearing identify themselves, starting with the judges, then counsel for the appellant, and then counsel for the appellee. Thank you. So I am Judge Elgo.
I am Judge Torres.
Good afternoon, Judge DiPentima.
Good afternoon, Your Honor. I am Pablo Ortiz, Jr.
Good afternoon. Oh, I'm sorry.
Go ahead.
Good afternoon, Your Honors. Sinead Rogers, counsel for Leslie Torres-Rodriguez.
All right, thank you very much. For the record, I note that I can see and hear everyone. Please let us know if in the course of your argument, if you are experiencing any difficulties hearing or seeing any of the participants. If you should lose your audio or video capability, please log out and retry the Teams link that you were sent for this hearing. We will, if there are problems, we will take a pause in the proceedings and await your return. All participants must keep their video on and remain in view out of respect for the process and for the other participants. We will also, all participants are also asked to keep your microphones off and muted when you are not speaking. The judges will raise their hand if they have a question to avoid talking over whoever is speaking, but will interrupt you if for some reason you do not see them. Please keep in mind that while this is a virtual hearing, all participants are expected to conduct themselves with the same formality and respect for the process as you would in our courtroom. Each side will be permitted 20 minutes of argument. The appellant may reserve a portion of that time for rebuttal and should advise me before you begin how much, if any, time is requested for rebuttal. Judge Suarez has agreed to keep time, and he will have signs with a 2-minute warning, 5-minute warning. Okay, and then what additional time?
2 minutes.
2 minutes. Okay, thank you.
Time.
And then when your time is up. All right. So we will now hear the matter of Ortiz versus Torres-Rodriguez, and the appellant may proceed. And if you would indicate, sir, how much time you would be seeking for rebuttal, if any.
Yes, Your Honor. Thank you so much. If I could request for 5 minutes.
All right. Got it, sir. Go ahead.
Thank you. And first and foremost, I want to thank the appellate court for this opportunity to present my case and the facts. I want to move right in because I know time is precious. And I just want to cover a lot of the areas that I believe are going to be the facts of the case. The first thing is, with all due respect to the attorneys representing the defendant, I just want to make sure that they understand I respect, and I respect the defense. But I have to come from the heart. And the first thing that I would like to say is that, since self-representing myself and really engulfing my life into this case, in my case as the plaintiff, I believe that the defense has made numerous statements of facts to continue to distort the facts of my case. In my humble opinion, their brief throughout has been about 3 factors that are not part of, which are ambiguities, loopholes, and technicalities. I believe that in my heart, these tactics by the defense are being used to create a perception of doubt. And for me, as the plaintiff, I've been throughout my briefs, and anything that I've done for the court have been one, unambiguous about my case. I stick to that. I believe in that. I want to cover the 3 counts that were in my complaint, which is count number 1, recklessness. I believe that the defendant and aforementioned parties were reckless and rushing to judgment in the firing of the hands of one of the aforementioned parties, Natasha Banks. In my humble opinion, it's reasonable to assume that the defendant not being able to know that she was running for the position of, at the time was acting superintendent, running for the position of superintendent, to not want to know of any information that was going to negate the amount of media that did. I felt that she was aware of the situation, was consulted on. It's apparent now regarding the briefs and that I got from the defense that she came and was aware of it, only because of the Hartford Board of Education and its policy that no one should be discussed to the media per any matter, and that was not the case. The policy was violated in the fact that she went to the media and knew and ran with it. At this point in time, I thought it was very reckless because there was no due process, no just cause for their rush to judgment. I want to say that it's important that the appellate court understand that at no time did I abandon my claim. At no time did I make such statement to even to any of my former attorneys on hand. I did ask in my preliminary statement of issues for the appellate court to reconsider that I did file a CHRO report, that there was some discrimination, of course, and egregious in terms of from the defendant and aforementioned parties, which was accepted. And so I believe that, in my humble opinion, they were reckless in that regard, and which to me is a question of fact. I wanted to touch base on count number 2 on intentional infliction of emotional distress. And I'm kind of nervous, but to me, it's reasonable to assume that any person or jury will find that their actions were premature, extreme, and outrageous, which to me is a question of fact. Having no facts is disputable. I believe that what hurt me the most also was that I was in therapy. I immediately went to therapy. My firing came on 1/27/17. On 2/3, I was in therapy. I was devastated, destroyed before the world, meaning my community, humiliated. And I was immediately in therapy. My therapist provided reports of what I was, going through, the hardship, the emotional stress and distress that I was going through. It caused me a lot of depression, anxiety. I lost weight, anxiety to the point where, I couldn't do much. I couldn't do much because I know that before the world, I know that in the community of Hartford, I was doing the best I can for our students of Buckley High School, and I just felt that I was destroyed. There was no doubt about it. My discovery and information by my therapist indicates a lot of that, and I felt that the defense minimized that, and I felt that was unfair to do. They're not licensed therapists to be making such claim that one such statement didn't impact me that way. That's not the case. In my humble opinion, the defendant and aforementioned parties, to me, their actions showed the world that me as the plaintiff, I believe in my heart I'm a victim of depraved indifference. I really believe that in my heart. As far as count number 3, to me, there's a question of fact with that. There's no doubt about it. We're liable. They publish, in my opinion, they rush to judgment without any basis, causing, again, extreme and outrageous conduct. It's my humble opinion. I believe in that. I think they published their opinion, not waiting for 2 investigations by the Department of Children and Families to be completed with no truth to their claim to the media. In my humble opinion, a jury could find that their opinion to the media or any article or statements that they've made was regarding me. At that point in time, there was nothing else that was being talked about. And in my opinion, I believe that the defendant and aforementioned parties were retaliating on the fact that the state of Connecticut found the Harper Board of Education to be negligent in filing and reporting. And it was an opportunity at that point in time to say, hey, this is a chance for me to use this platform as an acting superintendent to get the job, because I was changing the culture and making statements, not just one that was very harsh and unfair to me. I also say it because I was abruptly fired at my job at the Department of Children and Families. I'm a social worker, and I really believe that, although the department on 4 months I went through investigations, that I had to endure media at my home, my children. My son was put at risk, went to Buckley High School. I had to remove him on that day. I was threatened. This was a witch hunt, and they knew about it from an individual who was a fraud that applied to the Harper Board of Education. And they were derelict in their duty to making sure that this gentleman should not have been working for Buckley High School under my direction. They used the at-will, an at-will coach, myself, spending 10, 12 hours a day, making sure 7 days a week that I make sure that my student athletes graduated, that I changed the culture at Buckley High School. I gave them opportunities that they never had because I grew up in the same environment. For that to be taken away, and I knew folks in Hartford. I had goals. I had aspirations of one day running for mayor. I really did. I grew up in a housing project, and that was taken away from me. I believe my rights were violated, no doubt about that, in my humble opinion. And again, everything laid out by the defendant and aforementioned parties, to me, proved that I was, a victim of depraved indifference. And there are a lot of similar cases in Connecticut that go along the lines of what I've gone through. And so that's all in my brief. I spent thousands of hours from 513 when I took over my case and I filed the appeal. Engulfed my life, we're talking hours, so many hours, to making sure that the facts that I present are not a question of fact. And I honestly believe that the defense's entire case, it's about ambiguities. And I believe mine has been unambiguous throughout. I just believe that in my humble opinion. I know that for a fact, and knowing my case and what I went through and what is presented. But at this point in time, I just hope that the appellate court could understand that we wouldn't be here today if there was no merit in my case. And that's the way I feel. And that at any point in time, I was cleared. I was cleared by the Department of Children and Families. And there was never no investigation by the Harper Board of Education. And I just had wished that they had done that and let the process play itself out with due process. And that never was given or afforded to me. And that hurt. That hurt a lot because I was taken away from something that I love to do, and that was to help our youth in Hartford. One thing that affected me in terms of my emotions was that growing up in Hartford, I just wish that the defendant and aforementioned parties would know what I went through to have a gun pulled on you because you're trying to help a student athlete stay on the football team. They don't know how it feels to talk to a student right now, and an hour later he's dead. Those things are stuff that you just don't get away from. And I couldn't believe that something was taken away from me on the basis of a threat made by a fraud to the Harvard Board of Education that if they didn't fire me, he was going to go to the media. Well, of course, let the investigation play out. I just can't believe that those things happened to me, and I really believe that, in my humble opinion, I did the best. And if I had to do it again, I would do it the same way, giving every penny of my earnings as a football coach to those kids in the city of Hartford, so that I see they're successful. The rate of kids at Buckley High School when I took over in 2010 went up of graduating. It wasn't about wins and losses. It was about me seeing them off the streets, out of gangs, because that's where I grew up in. And I came back. I lost opportunities as a coach. I can't coach in Connecticut. That was taken away from me. And I'm damaged goods. If I try to find a job in Connecticut, which is what I love, I'm told that the damage that was done by the Hartford Board of Education, defendant and aforementioned parties, really affected me. And so I just know that, for the Hartford Board of Education, Pedro Zayas, to say, do not comment on anything that has to do with any personal matters of an employee of the Hartford Board of Education at the time, and for the superintendent to go and do that before, and emails in my brief, everything there is discovery, and for her to do that, you violated my rights, and I just feel that was wrong, and I was devastated, and until today, 3 years later, I'm still devastated. I'm still affected by it. I'm still in therapy, and my family suffered, and I just wish for justice. That's all I wish for.
All right. Go ahead. Does anyone have any other questions? Okay. There might be some feedback. I guess not. All right. All right. Thank you very much, sir. You will have 5 minutes on rebuttal, if you wish, after Attorney Rogers argues. Thank you.
Good afternoon, Your Honors. I just want to make sure before we get started that you can hear me just fine, you can see me just fine, that everything is situated the way it's supposed to be here today.
Yes.
Everybody else? All right, great. Okay. So, Your Honors, unfortunately, despite Mr. Ortiz's impassioned argument, Mr. Ortiz has failed to meet the standard required to overturn the trial court's decision granting summary judgment on his claims of recklessness, intentional infliction of emotional distress, and libel. That's the simple facts of this case. In fact, nowhere in his briefing has he even argued that the trial court's conclusions are not legally and logically correct. And he can't prove that the conclusions do not find support in the facts set out in the trial court's memorandum of decision. That's not even addressed in any way throughout his brief. Instead, Mr. Ortiz has referred to constitutional issues, due process claims, allegations of racial discrimination, and other statutory violations, when no such claims were included in his September 18th, 2019 revised complaint, which is the operative complaint in this case, and were the claims that were before the trial court during argument. These claims were not also included in any previous versions of Mr. Ortiz's complaint. He's also spent a great deal of time referring to conclusory allegations, assumptions about Ms. Torres-Rodriguez's motivations and her knowledge without any actual facts or evidence to back up any of those statements, nor does he have any documents or argument that were actually before the trial court that the trial court could have considered related to many of these issues that were raised in Mr. Ortiz's brief. Mr. Ortiz was not terminated due to a DCF investigation or under the Hartford Public Schools' abuse and neglect policy. He was terminated due to his at-will employment and not pursuant to any type of policy. Mr. Ortiz's complaint makes it clear that his claims are limited to recklessness, intentional infliction of emotional distress, and libel. The trial court fully considered briefing and argument on all of these claims and set forth a well-reasoned decision that is supported by the record when it granted summary judgment on each of these claims. The trial court correctly granted summary judgment with respect to Mr. Ortiz's recklessness claim, as Mr. Ortiz was unable to prove that Ms. Torres-Rodriguez engaged in the type of highly unreasonable conduct involving an extreme departure from ordinary care in a situation where a high degree of danger is apparent, which is the standard for recklessness. Conduct arising from momentary thoughtlessness, inadvertence, or an error of judgment is not going to be enough to indicate a reckless disregard for the rights of others. Now, Mr. Ortiz's recklessness claim, as stated in his complaint, was based on two separate issues. The first was his termination. Now, as to his claim related to termination, the trial court correctly determined that Mr. Ortiz had failed to offer any evidence that Ms. Torres-Rodriguez had actually been the one to terminate his employment. And he was not able to rebut the evidence provided that she had nothing to do with his termination. In fact, the record shows that there's no dispute that it was Natasha Banks, Director of Talent Management, who made the decision to terminate Mr. Ortiz, not Ms. Torres-Rodriguez, and that Ms. Torres-Rodriguez only found out after Ms. Banks had already made the decision that Mr. Ortiz had been terminated. Both within Mr. Ortiz's opposition brief and at oral argument on summary judgment, Mr. Ortiz's counsel stated not only that Ms. Banks made the unilateral decision to terminate Mr. Ortiz, but also explicitly stated that Mr. Ortiz had abandoned his recklessness claim based on termination. His counsel made that abundantly clear when, in his opposition memorandum, they stated that his recklessness claim really has nothing to do with the decision terminating him from his employment or failing to follow the abuse and neglect policy. Furthermore, the court correctly determined that Mr. Ortiz could not prevail on a recklessness claim related to termination due to his at-will employment. It's also undisputed by the parties that Mr. Ortiz's employment was at will. Mr. Ortiz stated in his opposition brief to the motion for summary judgment, Mr. Ortiz understands that as an at-will employee, he could be terminated at any time for any legal reason, and at oral argument affirmed the same. In fact, at oral argument, Mr. Ortiz's counsel could not have been more clear when he conceded this, when his counsel indicated in response to the judge asking, "Do you agree that your action is not based on the termination?" "Yes, I do, Your Honor." And the court said, "Because it is an at-will," and his attorney indicated, "I've conceded that, yes." So the court certainly determined that there was no issue of fact related to Mr. Ortiz's termination at all, as that claim had been explicitly abandoned both in briefing and at oral argument. Now, turning to the statement, which we'll call the press statement, related to Mr. Ortiz's recklessness claim. I assume Your Honors have reviewed this statement that is set forth in Mr. Ortiz's complaint, which is the first priority of Hartford Public Schools is to ensure student safety. As acting superintendent of schools, I will not allow any unacceptable staff behavior during my tenure. In the unfortunate event that, despite our best efforts to the contrary, individuals engage in inappropriate interactions with students, with their families, with staff, or with any of the visitors who come to our schools and events, such individuals will be dealt with swiftly in accordance with the policies established by the Hartford Board of Education. So as to the recklessness claim based on that press statement, the trial court correctly determined that Ms. Torres-Rodriguez's conduct in issuing such a statement did not meet the standard for recklessness. The court held that even if it was taken as true that the statement made it appear that Mr. Ortiz had engaged in unacceptable behavior, there's nothing, especially in light of the evidence of the complaints that were against him at the time that statement was made, to demonstrate that making such a statement was a serious or extreme departure from ordinary or reasonable standard of care, which is what is required to meet the legal standard for recklessness. And additionally, Ms. Torres-Rodriguez's statement was not a statement about Mr. Ortiz, but was rather a general statement indicating that as acting superintendent, she wouldn't allow inappropriate behavior from anyone. And in an instance where there were allegations of inappropriate behavior that had been made, Hartford Public Schools would deal with the issue swiftly and in accordance with policy. As to count 2, intentional infliction of emotional distress, Mr. Ortiz was unable to prove that Ms. Torres-Rodriguez had engaged in the type of extreme and outrageous conduct that is required for a showing of intentional infliction of emotional distress. In fact, I'm sorry, Your Honor.
Counsel, I have a question.
Absolutely.
Could you tell me what the context was of the press statement? Was it a response to a specific question before the defendant, or was it a written statement that was published in response to a written question? What was the context of the press statement?
Absolutely, Your Honor. So the context of the statement was that it was a statement that had been issued to the press. So what we've actually really focused on here within the complaint is the first part of Ms. Torres-Rodriguez's statement. And that's sort of what the appellant has put a magnifying glass on as far as what the actual statement was. But the second part of the statement provides the context for this statement. And I will provide you with the second part of the statement, which is, furthermore, we have recently provided enhanced district-wide training for employees regarding board policy on reports of suspected abuse or neglect of children or sexual assault of students by school employees. I have made it the highest level of priority for district leadership and for all staff to receive this training and comply with the board's policy. And importantly here, Hartford Public Schools is currently investigating allegations of possible failures in the reporting process and will comment further upon the conclusion of the investigation. So what you can hear from that statement is that what the statement is actually about is investigating possible failures in the reporting process, not any underlying conduct by any specific individual of abuse and neglect, but others who have failed to report such type of abuse and neglect.
Okay, but Mike, I thank you for that. But my real question is, so it was a statement, a press release, or was it a response to a particular question posed to them?
It was a
defendant.
My apologies. It was a press release, Your Honor. And actually, Ms. Torres-Rodriguez and the Board of Ed were asked explicitly on a separate question from the press about Mr. Ortiz's termination. And the only comment that arose out of that statement was, we cannot comment on personnel matters. So when explicitly asked about Mr. Ortiz, that was the comment that was provided in a separate statement, separate article. So as far as the statement that's actually at issue in this case, that is a separate statement entirely. And as Mr. Ortiz sort of alluded to previously during his argument, Hartford Public Schools had recently been subject of an investigation from the Department of Family Services regarding issues with reporting of abuse and neglect. So there had been a report that had come down that had been, actually it's referred to during oral argument on motion for summary judgment as a damning report that Hartford Public Schools was not doing a good job related to reporting abuse and neglect. So this statement, I think that report, which came out very, very soon in time with this, provides the context for this statement as well. And then that second paragraph references that issue. You know, we're ensuring that we're following policy, we're ensuring everyone's getting training, and we're also going ahead and we are investigating people who have not been reporting properly the way that they are required to do.
Okay, thank you.
Okay, great. So as far as Mr. Ortiz's claim of intentional infliction of emotional distress. He can't prove extreme or outrageous conduct attributable to Ms. Torres-Rodriguez. Now, again, that intentional infliction claim is based on two things. First of all, his termination. And as we've already gone through, Ms. Torres-Rodriguez did not actually terminate Mr. Ortiz's employment, nor did she consult with Ms. Banks, who made the ultimate decision to terminate Mr. Ortiz's employment. And she only informed Ms. Torres-Rodriguez of that decision after she had already made it. Now, Natasha Banks, who had actually made that decision, submitted an affidavit to that effect, indicating that she was the one who made the decision, that she informed Ms. Torres-Rodriguez after it had already been made. And Ms. Torres-Rodriguez's affidavit, supported in support of the summary judgment motion, also states that she didn't have the authority to terminate coaches. That was Natasha Banks's authority. So, I mean, she couldn't have terminated him even if she wanted to. She did not terminate him. As far as the press statement, which we've just discussed at length, there's nothing extreme or outrageous about Ms. Torres-Rodriguez making a statement clarifying Hartford Public Schools policy with respect to handling complaints about inappropriate behavior in general. To the contrary, Ms. Torres-Rodriguez's statement was not a statement about Mr. Ortiz, but was a general statement indicating how, as acting superintendent, she's not going to allow inappropriate behavior from anyone. And in a hypothetical incident where allegations of inappropriate behavior are made, Hartford Public Schools will deal with that issue swiftly and in accordance with policy. This is a statement about school safety, which is obviously very important to the public to receive, especially in light of that report that had come out of Child and Family, Office of Child Advocacy, that had stated that Hartford Public Schools was derelict in their reporting. As to the third count, libel, the trial court correctly determined that Mr. Ortiz's libel claim failed, as Mr. Ortiz did not claim that the press statement was intrinsically false in any way, which is a prerequisite for a claim of defamation to be actionable. Instead, Mr. Ortiz's attorneys advanced the argument that the statement insinuated that he was a child abuser. However, as we've seen from the statement, there is, number one, nothing about Mr. Ortiz in the statement by name or description whatsoever. And number two, it certainly doesn't indicate that he or anybody is a child abuser. While that was stated in his opposition brief to the motion for summary judgment in an oral argument over and over again, when actually pressed by the court about whether he could point to anywhere Ms. Torres-Rodriguez had called Mr. Ortiz a child abuser, Mr. Ortiz's counsel finally conceded, "I can't." Taking the statement line by line, Mr. Ortiz is not proved or even alleged that one single sentence in the statement is false. The first sentence of Ms. Torres-Rodriguez's statement is that Hartford Public Schools makes student safety its priority. This is not a false assertion that damages Mr. Ortiz's reputation, nor has there been an allegation that this statement is false. The second sentence in the press statement indicates that Ms. Torres-Rodriguez will not allow unacceptable behavior during her tenure. Again, there has been no allegation that that statement is a false statement or could do anything to damage Mr. Ortiz's reputation. As Mr. Ortiz is not mentioned by name, there's nothing in that statement that would lower Mr. Ortiz's reputation in the community. Furthermore, Ms. Torres-Rodriguez indicated that she would not allow unacceptable behavior while she's acting superintendent, which is a hyperbolic statement applicable to any employee and all employees' actions. It's not Mr. Ortiz's actions specifically and is not defamatory in nature. In the final sentence of Ms. Torres-Rodriguez's press statement, she stated that if any individual engaged in inappropriate interactions with students, family, staff, or visitors, that conduct will be dealt with swiftly and in accordance with policy. Again, there is nothing, or should say the trial court correctly found that there's nothing in that sentence or in any part of this statement that Mr. Ortiz is even alleged is intrinsically false, which is required for a claim of defamation. There are no false assertions in that statement whatsoever. As far as Mr. Ortiz's libel claim, alternative grounds also exist to uphold this decision by the trial court to grant summary judgment. The statement does not identify Mr. Ortiz to a third person. As I've discussed, it is a general policy statement about ensuring student safety. And additionally, Ms. Torres-Rodriguez is entitled to summary judgment on the libel claim, as she's entitled to a qualified privilege for the statement attributed to Mr. Ortiz, given Mr. Ortiz's status as a public official. Mr. Ortiz is a coach, and as such, he's a public figure for purposes of a defamation claim. Now, the courts in Connecticut have recognized teachers and coaches as public figures due to the fact that those types of positions, if abused, might cause serious psychological or physical injury to school-aged children. So unquestionably, members of society are profoundly interested in the qualifications and performances of these types of jobs where individuals are responsible for educating and caring for students. Likewise, Mr. Ortiz's job as a high school football coach, as he has just described to you, is of great public importance. You know, he indicated during his argument that he's done a lot for students, that he's done a lot as a football coach, that the students trust him, that he's very important to the community as a football coach. So he's a public figure for purposes of a defamation claim. And as a public figure, he needs to prove actual malice. And in order to prove actual malice, Mr. Ortiz has to prove that when Ms. Torres-Rodriguez made the statement, which we've discussed above, or I should say earlier at length, that Ms. Torres-Rodriguez knew the statement was false or acted with reckless disregard as to whether the statement was false at the time it was made. A negligent misstatement of fact or a failure to investigate, as alleged by Mr. Ortiz, it will not suffice to establish liability where actual malice is required. Rather, Mr. Ortiz has to demonstrate that Ms. Torres-Rodriguez purposely avoided the truth when she made her statement. And there is absolutely no evidence of that here, Your Honors. Even if Ms. Torres-Rodriguez's statement could be taken as a statement about Mr. Ortiz having engaged in unacceptable behavior or inappropriate interactions with students, there's no evidence that Ms. Torres-Rodriguez knew the statement was false or had serious doubts as to whether it was true. In fact, Hartford Public Schools had received a complaint from an assistant athletic coach accompanied by 28 student complaints that Mr. Ortiz had engaged in conduct, including verbal and physical altercations with students and parents, name-calling, bullying behavior, and question practices in paying assistant coaches and allowing assistant coaches to interact with students without certification or clearing background checks. So even taking is true, which certainly Ms. Torres-Rodriguez does not concede, that Mr. Ortiz had engaged in any type of unacceptable behavior or inappropriate interactions, there's no evidence that she would know that the statement was false or had serious doubts to its truth. That being said, as set forth above, this was a statement about policy in general and prioritizing student safety, not a statement about any one employee, including Mr. Ortiz.
Right,
I'm so sorry.
That's okay. You just need to wrap it up. Your time is up.
Okay. I just didn't hear what you said. My apologies.
That's all right. Just go ahead and close, please, and then, all right.
Yes, absolutely. So as far as Mr. Ortiz's allegations related to his 3 claims, Your Honors have the briefing that has been set forth in Ms. Torres-Rodriguez's brief, setting forth both the reasons why the trial court's decision was correctly made, as well as alternative bases for upholding the motion for summary judgment having been granted. And as far as that, Ms. Torres-Rodriguez rests.
Okay.
Thank you very much. All right. Mr. Ortiz, you have 5 minutes.
Okay, thank you so much. First and foremost, thank you again. I just want to sort of get back feedback in terms of defense's statements. The first and foremost, again, that's just an indication of distorting the facts. Their brief versus their summary judgment, there seems to be contradicting an admission to more than just it being one statement. There was a lot of media that was covered, and that the superintendent it is in my brief. I provided that information of her making not just one statement but other statements that any jury or any person can see that she was referring to me. There was nothing else being investigated. And the fact that Pedro's Eyes from the Harvard Board of Education issued emails that are in my brief to let even the superintendent, the acting superintendent at the time, that they should be making no kind of comment to the media about any personal matters would indicate, and it's very obvious, and why would she go to the media and make a statement or statements that she did? The other piece to this is that their affidavits and the depositions from my attorney at the time, Attorney Cooper, there seems to be contradicting statements. To me, it alludes to possible perjury. There's no doubt about it. I believe in that. I've been throughout my whole, proceedings in terms of my case since I've taken over. I have been, unambiguous. I've been clear, transparent, consistent, and compassionate to what has happened to me. All the facts that I've stated today have been ambiguous, evident. My evidence, free from any analogies, alternative, possibilities, or technicalities, or whatever it may be. But the bottom line for me, that my discovery is not predicated on question of fact. I believe that the defense's brief versus their summary judgment, there is a question of fact. There's no doubt about it. There's just false statements. To use the qualified privilege thing, for me, it was like, since she can do what she did to me, and not only just her, but the aforementioned parties that are part of the case that provided affidavits and depositions, they are part of the case. They contradict themselves in both the affidavit and the depositions. That is all part of my brief. At no time that I abandoned. That's why I'm representing myself. There's evidence that my attorneys were inept, with all due respect to them. And I just believe that throughout this whole case, it's just not been about one statement. You don't make a statement if the board has told you, and the person who's in charge of that tells you can't make any statements, and you do so. And so I really believe, in my humble opinion, that I'm a victim of depraved indifference. I really humbly believe that. There's no doubt about it. I ask, one last thing I want to say is that if you're a mandated reporter, and once I was cleared of 2 investigations, and I'm a social worker for the Department of Children and Families, there's no doubt that they were derelict again in their duty to file a immoral, emotionally abused report on Benny Foss, who was the person who was the fraud who threatened the Board of Education. Again, they were derelict as a mandated reporters to do such job. And that just says a lot about the Harvard Board of Education's just not following through with what the department has also offered them to do, is help them in making sure that they do their jobs correctly. As a plaintiff, I'm asking the appellate court. All I do is ask for justice and to be restored whole forthwith. Individuals that were suspended by the superintendent, 5 individuals were restored whole with. Either they were promoted or they were given back their opportunities to restore themselves. I was not. And all I'm asking is for the appellate court to reverse the ruling in a summary of judgment that the Superior Court ruled in favor of me, the plaintiff. I'm unambiguous on this whole thing, and there's no question of fact. There is question of fact on the brief versus the summary judgment that the defense has presented and so submitted. I did the research. I stick to I read it every night. I go to bed every night. I've lost a lot.
Sir,
of
I
sleep.
just need to Sir, I just need to interrupt. Your time is up.
Okay, no problem. Thank you so much.
All right. All right. Well, thank you very much. We will take this matter under advisement. Thank you again for participating in this virtual hearing, and we will stand in recess until 3 o'clock. Thank you.
Thank you, Your Honors.
Thank you, Your Honors.